Good afternoon and welcome.
Good afternoon, Madam Chair and members of the committee. My name is Amy McIntyre, and I'm from Prince William County. And as a woman, a feminist, a professional, and the mother of young adult women, I am passionate about authentic equal rights under the law. And indeed, I would be bold and venture to say that all of us here in this room cherish equality and equal treatment under the law. However, I urge us to pause and ask, what does that word mean? Because if we are talking about an equality of sameness, which erases the difference between men and women, then we are headed in the wrong direction. And indeed, I rejoice, as I'm sure everyone in the room did, about the accomplishments of all the ladies that Senator Saslaw mentioned. I will just point out that each of them achieved their goals without the Equal Rights Amendment. This is why I have come to oppose the Equal Rights Amendment, and I urge you to do the same. I am also concerned that our Commonwealth, which gave America 8 presidents, which gave us constitutional architects of brilliance like George Mason and James Madison, could, on this historic day, so dishonor the Constitution by pretending that this moot amendment can be ratified. Virginia is being asked to make history by becoming the 38th and final state to ratify the ERA, but the ERA is DOA, and it has been since 1982. On October 4th, 1982, in the case of Now versus Idaho, the Supreme Court dismissed it as moot, stating the amendment has failed of adoption no matter what the resolution of the legal issues presented here, because the ERA has not received the required number of ratifications. It is bad precedent to ignore precedent. Please don't put Virginia on the wrong side of history. Please be aware that harm may flow from enacting this. A flurry of litigation could ensue, which would be costly and damaging to our state. Thank you.
Thank you. Thank you very much. Good afternoon and welcome.
Thank you. Madam Chair, members of the committee, my name is Jacqueline Hawkins and I am from the Chesapeake area. As a Black woman, I have deep concerns about the ERA's possible effects on my community. The ERA has abortion consequences and they will be felt even more profoundly among us. Black women have the highest abortion rate in the country. We represent 11% of the female population, but have 28% of the abortions. To those who say the ERA has nothing to do with abortion, consider that in several states that have ERAs in their state constitutions, a right to taxpayer-funded abortion has been firmly established. In New Mexico, Right to Choose, Naral et al. Versus Johnson, the New Mexico Supreme Court ordered the state to pay for Medicaid abortions because they could not differentiate between abortions and the medical necessary procedures sought by men. The Supreme Courts of Connecticut and Washington have reached similar decisions mandating taxpayer-funded abortion for their state ERAs. The ERA is dangerous to all of Virginia's reasonable protective laws, such as the Women's Right to Know law, parental consent, and partial birth abortion law. If passed, the courts could decide that any of these laws are an impediment to women's access to abortion and overturn them. The ERA is designed to enshrine abortion as a basic human right that women must have, and pro-life laws interfere with that. Unborn girls and boys, especially the children of my community, will be among the greatest victims if the Supreme Court were to allow this version of the ERA to be resurrected. If a new ERA with abortion neutralizing language were offered, it might provide appropriate legal protections to states' rights to pass pro-life laws. It is not possible to add such an amendment to this version of the ERA. As a member of the Virginia Society for Human Life, we oppose passage of this pro-abortion version of the ERA. Please vote no.
Thank you for being here. Good afternoon and welcome.
Good afternoon. Madam Chair and members of the committee, good afternoon. My name is Kelly McGann from Prince William County, and I'm grateful to be here today to address you as a wife, mother, and a graduate of the University of Virginia Law School. I'm here today because I oppose the ERA. It's ironic that on this opening day of the 400th session of the Western Hemisphere's first representative assembly, you're taking up a bill that would transfer your authority over some of the most important personal rights of Virginians, including marriage, divorce, family, property law, adoptions, abortions, schools, and sports, from our state to the federal government. Section 2 of the ERA states that the Congress shall have the power to enforce by appropriate legislation the provisions of this article. Congress and the federal courts will thus decide, not the people of Virginia or any other state, what sexual discrimination is, and this will mean an avalanche of lawsuits disrupting the lives of women in our state and across the country, who will no longer be able to rely on existing common sense laws to protect them. The ERA may sound benign and symbolically important, but it failed in 1979 and ultimately in 1982 because people recognized its vague promises would not advance the cause of freedom and protection for women, and this is even more true today. Section 1 of the ERA does not even mention the word woman or women, referring only to equality of rights on account of sex, a term which enjoyed a common understanding in 1972, man or woman, but does not in 2019. Thus, it is inevitable that any person seeking to protect their rights under this amendment will need to seek the intervention of the courts and will not be able to rely on any laws that currently protect them as a man or a woman. It truly is a Full Employment for Lawyers Act. Lawyers around the nation will thank Virginia for all the new business. Laws drafted specifically with women in mind we take for granted will be in jeopardy. The ERA is unnecessary in 2019. It's not 1972. Women are protected by the 14th Amendment and a long list of federal laws. All these laws would be superseded by the ERA. The law as written is too extreme. Women deserve better. Please vote no on the ERA.
Thank you very much. No. Please be respectful. Good afternoon and welcome.
Madam Chair and members of the committee, my name is Tony Delancey, and I'm the State Director of Concerned Women for America for Virginia. And on behalf of over 500,000 women across this country, we ask you to oppose the Equal Rights Amendment. The ERA will actually end up hurting women in many ways. Here's how it impacts women in the military. I know we've talked about it, but here's a personal example. Senator Sass talked about West Point. Well, in the late 80s, I attended West Point. I graduated from the United States Military Academy with about 80 other women out of a class of 945. I commissioned that day as an officer in the Army, and I went on to lead men and women in a tactical intelligence unit. This was the privilege of a lifetime for a man or a woman, but my women classmates and I did not need the ERA to accomplish this. We volunteered and we competed, and we were able to serve based upon our individual strengths and our unique abilities. Women today, as we said, are accomplishing more than ever in the military, and they enjoy the right to volunteer and compete to do those remarkable things. As Senator Sass said, serve in the combat units if they make it. Passing ERA would actually change this. It would force equal representation of women in all combat roles. This would impact readiness. It would put people in roles for which they are ill-suited. If passed, a future war would require women to be drafted. Passing this is not the right thing to do. We already have equal rights. I'm an example. ERA hurts women and would indeed hurt our nation's armed services. Please vote no. The Concerned Women for America of Virginia, thank you.
Thank you very much. Good afternoon and welcome.
Good afternoon, Madam Chairman, members of the committee. My name is Colleen Holcomb. I'm an attorney from Yorktown, Virginia. I represent Eagle Forum and the Virginia Family Foundation. Now, today you've heard some of the troublesome aspects of the Equal Rights Amendment. And if the present political climate is demanding some legislative affirmation of women's equality, don't women deserve more? Don't women deserve better? The procedural issues absolutely do matter. As you've heard today, the ERA actually, it did expire on March 23rd, 1979. The deadline was purported to have been extended, but even the Carter administration and the Congress that passed the Equal Rights Amendment and purported to extend that deadline specifically said, and this is quoting from John Harmon, who was the Assistant Attorney General under President Carter, certainly if a time limit has expired before an intervening Congress has taken action to extend that limit, a strong argument can be made that the only constitutional means of reviving the proposed amendment would be to propose the amendment anew by a 2/3 vote of each house. That never happened. The deadline was extended on the basis of a voice vote. That was a constitutional fraud, and that's unfortunately what's attempting to be perpetrated today. Even at the time, Congresswoman Griffiths, who was one of the champion sponsors within Congress, stated, "I think it's perfectly proper to have the 7-year statute so that it should not be hanging over our heads forever." Here we are 40 years later. Senator Harkey, a supporter of the resolution, stated, "If there is such a delay beyond the 7 years, then we must begin the entire process over again." Don't women deserve to have something as important as equality considered within a contemporary time frame? I urge each member of the committee just to take a look at the Gallup poll's congressional approval rating over the past several years. It's a great day for Congress when their approval rating gets into the 20s, even into the teens some days, and it hasn't gotten above 30 since 2009. Is this really the body we want to empower to be the arbiters of equality?
Thank you very much. Please, let's be respectful. Okay, Senator